Your silence is commanded.
Please be seated. Well, we have a full house today on this rainy old day. Some of the people who are with us are students that participate in a program that the court operates in coordination with the State Bar of Wisconsin called Court with Class. This morning we have Palmyra Eagle High School. Would those students please stand? And their teacher? Very good. Thank you very much. You may be seated. We'd like to have you come and visit us. Hopefully you'll all generate a big interest in a career in the law, and we'll have that to come out of this. But if nothing else, you'll see a little bit about how your Supreme Court operates. When we are done with this argument, which is the only one that we have this morning, Justice David Prosser will come out and speak with the students, not about the substance of the case that we're hearing, but just a little bit more about how the court operates, how does it take cases, and whatever other pearls he tends to give during his discussion with the class. Now, I've introduced the students and by having them stand up, so we got to see who they are. So I'll introduce the court to all of you. On my far right is Justice Michael Gableman. Next to him, Justice David Prosser. Next to me, Justice Abrahamson. I'm Pat Rogensack, the Chief Justice. On my left is Justice Ann Walsh Bradley. Next to her, Justice Annette Ziegler, and on the end, Justice Rebecca Bradley. With our introductions made, I'll now call the case for today, Coyne versus Walker, 13 AP 416. Now we have a little bit of a breakdown on how we're going to do the argument this morning. Do we have a sheet on that, Tina, who gets what, so that we can agree? Oh, I got it, thank you very much. Let me put my glasses on and then I'll be able to read it, which is also helpful. Okay, to begin with, Attorney Meany will have 30 minutes. Then Attorney Essenberg will have 5 minutes, followed by 23 minutes for Susan Crawford, followed by 12 minutes for Ryan Nettleston, and 5 minutes for Michael Julka, and 5 minutes in rebuttal for David Meany. Does that meet with what you all think you're going to be doing today?
Yes, Your Honor.
Super. All right. Before you begin, you're fairly tall. You might want to raise the podium a little bit. There's a button on your left that allows you to do that.
Right.
Our speaker system in here is sometimes hard for us to hear, even though you're very close to us. So if you can do that, that would be great. It's magic, right? Very good. Thank you so much, and please begin.
Chief Justice Rogenstack, may it please the court. Under any reasonable analysis, this case is a separation of powers case because it involves the relative powers of two branches of Wisconsin government: the legislature's power under Article 4 of our Constitution and the executive's power under Article 5. It also involves the power of the Superintendent of Public Instruction, an executive officer within our divided executive branch, and the superintendent's power specifically under Article 10, Section 1 of the Constitution. I'd like to direct the court's attention in evaluating the separation of powers principles that are present in this case to the numerous concessions made by the respondents in this matter. Some of those concessions are echoed in the decision of the Court of Appeals. Specifically,
Counselor, could I just ask, you keep saying separation of powers. To me, this is more of a how is power dispersed within the executive branch case. And then when I look at the language of the Constitution, I'd like you, for me anyway, to address how the legislature can take from one executive officer and give to another executive officer certain power, and also address Article 5's language, which references the executive power being vested in the governor, and then Article 10 that talks about the supervision of public instruction being vested in the state superintendent, and how that language of the Constitution has any effect on my issue, which is the dispersal of power within the executive branch.
Well, thank you, Your Honor. I think that's a point that has been raised by the respondents in this case. And I think you have to look at what Act 21 relates to. Act 21 relates to a legislative power. That is conceded by all parties in this case. And it is the legislature's decision as to how to delegate that power to the executive, as occurs in administrative rulemaking. So at the core, what we're looking at is the power of the legislature, the administrative rule process, and the power of the executive branch. In this case, initially, under rulemaking, the power is delegated to the superintendent of public instruction, an executive branch officer. The fact that the legislature, in exercising its power to control the administrative rule process, has also delegated power to another executive, the governor in this case, does not make this a dispute between the two executive officers. It is at its core the control of the legislative power by the legislature to control that administrative rule process. So I don't think it turns it into a dispute between two members of the executive branch.
Well, it sure does seem, doesn't it, that they're taking authority that the state superintendent would presumably have, and instead saying the governor can kind of trump that authority.
Well, the authority that is given to the superintendent to promulgate rules, as with other executive agencies, statutes provide that rules may be promulgated to fill in the statute. That's what Chapter 227.19 provides. That's the whole structure and scheme of administrative rulemaking. That power carries with it the ability to control the delegation, and the legislature can decide that when it delegates that authority, to split that authority with another executive officer, and it has done so in this case. It's part of a procedural safeguard that the legislature believed was necessary for the administrative rules process.
Do you place any emphasis on the language of the Constitution that says the executive power shall be vested in the governor?
As a general statement of our separation of powers, we would have obviously no dispute with that. I don't believe that conflicts with the concept of administrative rulemaking being a delegated power of the legislative branch.
I just wondered if you thought the executive power meant of the executive officers, the governor has a supreme executive power, or
Yes, the governor does under the Constitution over the executive branch. What we have here, though, is a situation where, in particular with the superintendent, we have a divided office within the executive branch. It's a constitutional office, but the respondents don't contest that the superintendent is an executive officer within the executive branch.
thank you. I'm sure my colleagues have questions for you.
I do, thank you. Counsel, if this court would view this case not as a separation of powers case, but rather a case with powers dispersed within the executive branch, do you lose?
I don't believe we lose, Your Honor, because, again, you must go back to the role and the undisputed power of the legislature to control administrative rulemaking. The legislature can decide.
Excuse me, but both of your arguments that you advance, as I understood it, your first argument that Act 21 is a limit on legislative rulemaking power, and your alternative argument, to the extent that the challenged provision of Act 21 affects power shared between the legislature and the superintendent. So I took both of your arguments in your brief, anyway, to depend on this legislative power versus the superintendent's power, which is conceitedly executive. Am I wrong on that? I mean,
I
isn't
think in
your
that general
argument?
sense, you're correct, Your Honor, that this does relate to the legislative power to control rulemaking vis-a-vis the constitutional power of the superintendent, which is limited to a supervisory power, an executive, which can be characterized, we believe, as an executive supervisory power. And that power in Article 10, Section 1, does not control the legislature's ability to control the delegated rulemaking process.
But doesn't Act 21 interfere with the superintendent's ability to carry out his constitutional supervisory duties? Or could it possibly, if the governor decides to veto something that the superintendent of public instruction, under his watch, an administrative rule is proposed that would help the superintendent carry out an aim or a purpose that would be part and parcel of the supervisory function? It wouldn't seem to me, it doesn't seem too difficult to envision a scenario where that could be blocked or checked by a governor who would not be friendly towards that.
Your Honor, I think there are several points to be made in response. One, the legislature has viewed this by the structure of Act 21 as an additional procedural safeguard on the administrative rulemaking process. To the extent that...
I don't know how that runs to the idea, though, that if a governor had a mind to block something that the superintendent thought was necessary to carry out his, we're talking about constitutional principles here, so we all want to tread very, very carefully. So if the superintendent says, I need this in order to carry out my constitutional duty, and then you have a governor, any governor, who says, no, I don't think that's right, I'm gonna block you from doing that. Isn't that interference with a constitutional officer's duties?
Well, there are mechanisms, and this is where we part ways with respondents. Again, the legislature has made the judgment that that is an appropriate safeguard. To the extent that, and this applies also only to new rules, to the promulgation of new rules, to the extent that the superintendent proposes a scope statement under Act 21 that is not approved by the governor, and the legislature decides that it disagrees with the governor's veto, if you will, is not absolute, and that's where we disagree with the respondents. The superintendent can also always go to the legislature and obtain, if the legislature does not agree with the governor, obtain
Through legislation,
through
what it could not
legislation
achieve
the
through the
same
administrative result.
the same administrative result through a statute. Now, of course, that statute would be subject to the governor's veto, but it would be subject to override by the legislature, and that really is a playing out of our normal give and take process where we end up
That sort
with
of is
policy.
the safeguard that your client seems to be relying on for why this would not be an impermissible intrusion upon the superintendent's constitutional duties for supervisory acts.
Yes, Your Honor, and we start out first, not to miss the point, that the promulgation in the first instance of legislative rules is not within the executive supervisory power under Article 10 of the superintendent.
Sure, it would be the substance of whatever is proposed.
Well, why can't the superintendent, instead of labeling something a rule or a regulation, why don't you just label it an executive order by the superintendent? And do the same thing as a rule or regulation?
Well, I think that would raise a different issue as to whether the superintendent was acting within the powers and duties given by the legislature, Your Honor, which everyone recognizes is permissible under Article 10.
Well, no, it raises the question of whether whatever you call it is a rule, because rule is so broadly defined that it covers everything. I'm trying to find out what it doesn't cover. It covers policy, it covers internal operating procedures, it covers everything.
The legislature has determined what directives or policies, in a general sense, that any executive agency, when the agency tries to implement them, whether or not that requires rulemaking. I mean, that is a staple of the analysis under administrative law. Does an action by the agency, can it be an informal policy, or does it require rulemaking? And obviously, if it requires rulemaking, Act 21 would then apply to that process.
What doesn't come under rulemaking? Now, I noticed that you have footnote 5 on page 8 of your reply brief, and you say, does the DOJ have any rules and regulations?
Yes, Your Honor, the Department of Justice does have administrative rules.
Okay. So because they're covered by this act, right?
Yes, the Department of Justice covered by Act
So
21.
it operates in a crime alert network without any rules, it says. Well, it must have a definition of what the employees are supposed to do. It must have a statement somewhere about how this crime alert network works, who does what to whom, when, right?
There are certain, of course, internal operating procedures within the Department of Justice, as any other agency, to cover more mundane aspects of the government's operation.
Well, the definition of rule is very broad in the statute, right? Let's just read it together. It's 227, right?
Yes, Your Honor, it's covered in Chapter 227.
Oh, it goes on forever.
No, it doesn't go on forever. It defines rules and then says there are a multitude of exceptions to the rules, but I didn't see the criminal alert system as an exception to the rules. Is there an exception to the rules?
Section 13 of 22701
Right.
defines rules, but it has examples, parent A, parent through parent Z, V, parent. So it would take quite a long time to read them all today. So if you have a purpose and you need them read, I won't stand in the way. No, in fact, it goes further. It goes to parent Z, ZZ, parent. So there are lots of
And we don't
examples.
have to worry about the examples because I don't see anything in there about the DOJ and its alert system. And it says, rule means a regulation, standard, statement of policy, or general order of general application, which has the effect of law and was issued by an agency to implement, interpret, or make specific legislation enforced or administered by the agency, or to govern the organization or procedure of the agency. That's what it says. It then goes on to say, rule doesn't include the following. I'm not interested in that unless you can find me an exception that covers the example you gave, which I couldn't find, but that doesn't mean it's not in there. So it seems to me almost everything. I'm trying to think of an example that isn't a regulation or rule under 13. And then there's another provision in here that is as broad.
Your Honor, if I may, the administrative agencies need to make decisions at all times as to whether certain operating procedures or interpretations of statutes require rulemaking. to the extent the superintendent of public instruction has made that decision, I'm sure. Remember, Your Honor, that rulemaking is often directed by the legislature in the statute that establishes the program or the process at issue. So there is a directive that this, any policy necessary to carry out this statute, the legislature has already made the determination that an administrative rule is appropriate.
So anything not covered in the statutes by a rule is not a rule? Is that what you're telling me?
No, Your Honor, I'm not saying that. What I'm saying is that the agency will make the determination, just as the determination has been made up until this point, as to whether or not a certain policy or procedure that it wants to put in place requires rulemaking. If it does require rulemaking, then Act 21 applies.
That's how I started this questioning, saying, can't the superintendent decide that it's not a rule and promulgate it as a general executive order or something else?
Hypothetically, the superintendent could make a decision which was contrary to our body of administrative law as to what is a rule, and then the legislature obviously would have the opportunity to take action directing the superintendent that he or she could not do that.
I think if I understood your point earlier, tell me if I'm wrong, it can be boiled down to what the legislature gives, the legislature can take away, or at least modify.
That's correct, Your Honor, and that is the essence of the legislative rulemaking process. It is the essence of Article 10, Section 1, which says that the superintendent's duties are to be prescribed by law.
And one of the ways that the legislature chooses to do that is to permit each agency, to the extent the legislature chooses to delegate or to repose within the agency the authority to pass administrative regulations that have the force of law. To the extent it chooses to do that, it can choose to withdraw authority or to modify that authority. And I think I see, am I summing it up
Yes,
correctly?
or place conditions on that authority.
Right.
The
Well,
condition here
that would be
being...
under modify. And so the tack you're taking would seem to be, it's not a clash of constitutional authority or duties that are prescribed to each of the executives, but rather it is an exercise of legitimate legislative ability to modify the grant of authority that it is given to particular agencies to create their own rules.
Yes, Your Honor, and it's a clash in the sense that, in this case, the superintendent has disagreed with the restrictions.
I'm only talking about a clash in the sense, I'm worried about the Constitution.
Yes.
Of course I care about the particular administrative agencies at play here and the executive, of course I care, but my eye is on the Constitution. And you're saying this is not the constitutional crisis that some would paint it as, because it has to do with the legislative, the authority that rests with the legislature to provide, modify, remove, restrict, or whatever word you used, I can't remember, the rulemaking authority for the respective agencies.
Yes, Your Honor, that's what Act 21 does. That's what distinguishes this case from the Act 27 of 1995, which was the subject of the Thompson case, which went to the executive supervisory powers.
And you're saying that as a safety valve, the safety valve there is if this, in this instance, it happens to be the superintendent of public instruction. If the superintendent sees a rule or a law, let's call it what it is, as being necessary to fulfill his functions under the Constitution, the safety valve is to go through the legislative process.
Correct, Your Honor, and that may not be necessary because the legislature may agree with the action of the governor, either at the scope statement stage Act 21, which is Section 4 of the Act, or the approval of the final draft rule. And if I could return to the concessions in this case, because I do think they frame this court's approach to the issues that have been raised so far. The next concession made by respondents is that the power to engage in administrative rulemaking could be withdrawn from the superintendent at any time by the legislature. And that power, of course, springs from the legislative rulemaking process itself. And also, the Court of Appeals recognized that power. And again, it sets up a conflict with the overall position of the respondents in this case. In addition, at page 6 of their surreply brief, the plaintiffs' respondents concede that they have not argued that the superintendent has the constitutional authority to make administrative rules. We think that's a key concession in this case.
You would say that's purely a legislative authority?
Correct, Your Honor.
Counsel, back in my mind to your very recent comment of trying to distinguish the Thompson case from 1996 with the issue before us today in Act 21. But the Thompson case said at pages 698 and 699, indeed, that the constitutional difficulty with the education provisions of then Act 27 is not that it takes away power from the office of SPI, but rather it gives power of supervision of public instruction to another officer. And so it seems to me that for your position to prevail on the question of whether or not the legislature can take away this power, or they can't take away this power, necessarily implicates whether or not Thompson has to be overruled.
As our briefs show, Your Honor, we don't believe that it is necessary for this court to overrule the broad rationale of Thompson.
How about the specific rationale of Thompson?
Well, if the
Including what I
specific
just
rationale
read.
is the one you cited, or generally speaking, that the legislature cannot give any supervisory power equal or greater to any other officer, if the court believes that Thompson cannot be properly limited to legislation that relates to the executive supervisory powers of the superintendent, which is not what Act 21 does. It relates to the administrative rulemaking powers of the legislature. But to the extent that this court believes that it cannot get around that broad rationale, we would ask the court to overturn that broad rationale and return to the original, the meaning, the plain meaning of Article 10, Section 1. And we would ask the court to follow the reasoning in Justice Wilcox's concurrence in Thompson. Justice Wilcox concurred only in the result under the facts of Act 27 back in 1995, which did things far different to the powers of the superintendent than Act 21 does. But we would follow that reasoning where Justice Wilcox rejected we would believe, unnecessary broad rationale of Thompson.
So your alternative is, or your fallback argument includes, if you can't see fit or appropriate to limit Thompson, indeed it has to be overruled. Is that right? Because I was going to ask you, Mr. Essenberg's going to stand up in a few minutes, and if his argument is consistent with his brief, he's going to say, overrule Thompson. And my question was going to be, so what's wrong with his argument? So, but that's your alternative argument to overrule
That is correct,
council?
Your Honor, that this court believes that Act 21 and its relationship to the duties of the superintendent under Article 10, Section 1 cannot be put together in harmony, then we do believe that that broad rationale of Thompson must be overturned. And for the reasons, again, in a nutshell, that Justice Wilcox laid out. Justice Wilcox focuses on the plain meaning of Article 10. He also takes issue with some of the presumptions that the Thompson Court made as to the legislative history of the adoption of the Constitution of Article 10 in 1848. He focuses instead on the 1902 amendment. That is the most recent visit that the legislature made, and indeed the people of the state when they adopted it. And Justice Wilcox found nothing in either the plain meaning of Article 10 or the 1902 amendments or the debate which made the superintendent superior to all other officers in all respects and under any scenario.
Counsel, one of the statutes that's challenged is, or spoken about, is 227-137-6, which addresses proposed rules that would have an economic impact of $20 million or more. And then if it does, Department of Administration has to review the rule. What is, before the enactment of that section, what happened with expenditures that were $20 million or more? How were they handled if they were the effect of a proposed rule?
I believe, Your Honor, there was the requirement of a statement as to the economic impact, but there was not the requirement that Act 21 imposed requiring the Secretary of the Department of Administration to pass on the economic impact statement.
So, well, there must have been some supervision of the money that was spent regardless. I mean, they surely supervise our money from the court. So I can't imagine that the secretary had the ability to have DPI pass any rule and put a economic impact statement on it that was $50 million, and that was the end of the story.
Well, Your Honor, under prior rulemaking procedures, for example, once and this is not part of the scope statement, this is part of the proposed final rule,
Yep.
It went from the agency to the legislature and did not have that intermediate requirement of approval by either the governor or the secretary of the Department of Administration. But it was accompanied, as I understand, by a report to allow the legislature to assess on its own what the economic impact would be of the proposed rule.
Okay, so what the legislature delegated then in 227-137-6 is delegated to DOA to make a review that it had made in the past of the economic impacts of proposed rules. Is that?
I believe that's the correct way to describe what has occurred, Your Honor.
Doesn't the DOA
so-
have a veto power?
Okay, excuse me just a minute, I just want to finish my questions. So if that is the case, the secretary, it would have been a shared power always between the legislature and the secretary's office on whether the rule could go forward given the economic impact that was going to be attached to it.
Well, certainly the legislature, in its consideration of a proposed rule, has its own inherent authority to reach out to any part of the executive branch to get input as to the economic impact of the rule, and I'm sure that took place. What Act 21 did was require the approval for certain types of rules having a certain level of impact of the secretary.
Okay, thank you.
Now, under 6, the secretary's approval is needed for it to go forward. That's different than a fiscal impact statement.
That is correct. The secretary considers the economic impact statement of reaching that, and that has been an issue in this case, though the focus has obviously been on the governor's role in approving scope statements and proposed final rules.
So the agency may not submit a proposed rule to the legislature for review until the agency receives a copy of the department's report and approval of the Secretary of Administration. That's new.
Your Honor, Chief Justice, I notice my red light is...
Yeah, please answer the question. Thank you.
Excuse me, Your Honor, could you repeat the question?
I said under subsection 6, the DOA has to approve this report before the agency's rulemaking would go ahead.
Yes, that is correct, Your Honor.
And that's new compared to the old statute.
Yes, that is new in Act 21.
Thank you very much.
Mr. Meany, there is a table of contents for the Wisconsin Administrative Code. Does Act 21 apply to all the rules in the Wisconsin Administrative Code?
Act 21 applies to new rules that are being promulgated, Your Honor,
New rules?
that are coming through. The provisions of Act 21 at issue here apply to new rules that are being promulgated by administrative agencies.
Okay, so the definition of agency is pretty broad, is it not? The definition of agency is pretty broad, is it not?
I believe that's correct in terms of what bodies need to comply with Chapter 227, yes.
Would that apply to the Judicial Commission?
To the extent that it did not involve other distinct separation of powers issues, it would have to be examined as to whether those requirements in Act 21 did impinge on a constitutional function reserved to the judiciary.
Well, that really isn't the judiciary, the Judicial Commission. The Director of State Courts promulgates rules.
Yes, and we would take the position that Act 21 does apply to
To the Director of State Courts. And to the Public Service Commission?
Yes.
And the Government Accountability Board or anything that succeeds it?
Yes, Your Honor.
Are there any limitations on this sort of approval power by the governor of any agency that's not covered?
Well, to the extent that if an agency is not covered by Chapter 227 rulemaking requirements, then Act 21 would not be implicated and the governor would not have a role, if I understand the question correctly.
Is it your position today that the Attorney General has no problem about a governor being able to say the Department of Justice cannot proceed with a rule?
As I mentioned before, Your Honor, the department has taken the position that Act 21 applies to the department. It should be noted that the Attorney General, under our Constitution, has only those powers and duties prescribed by law. There is no analogy to Article 10, Section 1, but the department has taken that position. Again, with the safeguard that if the department believes that the governor is not permitting something to go forward that is, in the view of the Attorney General, critical to the mission of the Attorney General, the department would have the option of going directly to the legislature.
Thank you very much,
I
Counsel.
have one other question. If the department, any department, wants to amend an existing rule, that comes under these new rules, right? Correct. Okay.
Thank you.
And is the Department of, the Superintendent of Public Instruction sui generis in the Constitution? In other words, is there any other officer that has the same power and as here is vested in the superintendent, with the statement that the legislature can appoint or nominate or name other officers. I could find nothing that was substantially similar.
I
Is there
believe,
something?
Your Honor, I believe that's correct. The Secretary of State, the Treasurer, and the Attorney General do not have statute or constitutional provisions similar to Article 10.
But I noted that that the legislative branch has legislative policy or legislative powers are vested in the legislature, the executive powers are vested in the governor, and the judicial powers are vested in the court system, with the legislature being able to set up trial courts, right?
Yes, sir.
Legislature, yes, so I assume that the legislature might be limited in setting up trial courts and doing things by the fact that power is vested in the court system, in the judiciary.
I would not agree with that in a general sense.
Pardon me?
I would not agree that the legislature would be limited in establishing our court, the structure of our court system.
Okay, thank you.
Thank you very much.
May it please the Court, thank you for the opportunity to address you this morning. If respondents are correct, Thompson took language that says that the power of supervision shall be vested in the superintendent and such other officers as the legislature may direct, to mean that this power shall be vested in the superintendent and no other officers. If that's correct, as Justice Wilcox and Steinmetz feared, the impact of Thompson's broad language has become unjust and unworkable. Not only, according to respondents, must the superintendent retain some core authority, or even more authority than everyone else, no one may be tasked, vested, with a power that is free, that is not subject to the superintendent's control. The superintendent may not be made, as here, to seek the concurrence of anyone else in anything. The legislature must commit each and everything it does in public education to the control of the superintendent or not act at all. Thompson's broad language transforms a shared power to be allocated by the legislature into the sole and absolute power of the superintendent. Even the governor.
Professor, what you are saying seems to be entirely consistent with one of the two letters from the superintendent of public instruction, Lorenzo Dow Harvey. The majority in Thompson relied on one letter. Justice Wilcox, in his concurrence, points out another letter in regard to the 1902 amendment, where Harvey wrote, "The only purpose in the amendment beyond that of making it possible to put the election of county superintendents in the spring was to make the provision broad enough to meet any demand of the people at any time in the future in the organization of the school system." And it seems in our representative democracy, the people act through their legislature, as your co-counsel has already argued. The emphasis here is on the power of the legislature to either grant, modify, or eliminate the rulemaking authority. So is there anything inconsistent in your argument with what Superintendent Harvey expressed as the purpose of the 1902 amendment?
No, I don't think so. If you look at the extrinsic sources, well, if you look at the plain meaning of the text, I think that it's quite clear
That should end the
that
inquiry
the power
according to your, yes.
is shared as determined by the legislature. If you look then to the extrinsic sources, one might conclude that the superintendent has more than exhortatory authority. The Thompson Court did that. One might conclude then that the superintendent cannot be completely stripped of his or her authority, and that perhaps then Thompson was correct in its result, if not in its broad language. Because if you read that broad language, the way that the respondents urge you to, then not one jot or tittle of the superintendent's authority may ever be given to someone else. And that, I would submit, is impossible to recognize, to reconcile with the clear constitutional text, and is not compelled by any of the extrinsic sources.
I'm not sure that's right. Thompson talks about the supervisory authority that is granted under the Constitution to the SPI. And I say, I'm not sure that's correct. I'm not sure it's wrong either. But if we focus on what does the supervisory authority mean, and how, if at all, can it serve as sort of a shield against the legislature exercising its authority to grant, modify, restrict, or eliminate the delegation of rulemaking authority to the agencies? That's not entirely clear, but I think you're following.
And here I think where this is at least analogous to a more traditional separation of powers case in which we sort of find ourselves within the borderlands of power. And one of the things it seems to me that the court could do in this case is it could say, look, rulemaking is a delegated legislative authority, and just as the governor checks the exercise of direct legislative authority, he may also check the exercise of delegated authority. But my light is on, and although I have more to say, I have no time to say it.
How would you deal with the technical college system and the university system?
How would I deal with the technical college or the university system? Well, I think that those agencies would be subject to certainly be subject to Act 21. It seems to me that it is the case that the superintendent has to retain some authority. That is, the legislature could not relegate the superintendent to a desk, outside in the rotunda where, he could hold up signs and say, public schools are a great thing. But to say that because the superintendent cannot be completely stripped of his or her authority, to say that that means that the superintendent may not be compelled by the legislature in light of the exigencies of the times to share authority with another officer is an entirely different question. And it seems to me that the plain meaning of the text speaks to that, and none of the extrinsic sources undercut that plain meaning.
Thank you very much.
Well, if I may, what I'm really trying to get at is that the superintendent of public instruction plays a role with the university system. And I believe the superintendent plays a role with the technical college system. But I don't think he's the boss of either one of them. And so that power has been, if he ever had it, has been taken away.
That's right, nor is the superintendent the boss of over 400 school districts throughout the state of Wisconsin. The superintendent cannot fire the superintendents of those school districts and cannot engage in their daily management. To say that the superintendent, even to say that the superintendent must be the primary officer of public instruction in this state, does not mean that the superintendent must be the boss in each and every way, and that everything that the legislature might want to have done in this very, very important and very, very huge area of public policy has to somehow be submitted to the control of the state superintendent of public instruction, or the legislature may not act at all.
Thank you.
As I read your brief, you think Thompson has to be overruled. Thompson v. Craney has to be overruled. It cannot just be distinguished.
Justice Abrahamson, we get into this sort of metaphysical question of to what extent is the rationale of a decision part of the holding, and we know that to some extent it is. My position and the position of the parties I represent is that we're not asking the court to declare that the result in Thompson was wrong, but that this broad language, at least as it's interpreted by the respondents here, goes too far. Now, whether this court, and you're sitting up there, I'm sitting down here, so it's your determination. If this court believes that that can be done by clarifying the language of Thompson, I will be a very, very happy lawyer. Whether or not you have to overrule it or clarify it, it seems to me that the key thing is to make clear what the proper scope of Article 10, Section 1 is.
And what do you suggest that we would say?
I would say that Article 10, Section 1 provides that the legislature may allocate authority between the state superintendent and whatever other officers the legislature may so prescribe. This does not mean that the superintendent must be superior with respect to each allocated power, or that an other officer may not be tasked to check the exercise of authority of the superintendent, at least insofar as the superintendent retains an important public role with respect to the supervision of public instruction.
You know, the Chief Justice and the members of this bench know that I very seldom ask a question after the red light is on, but I'm going to make this observation. I've been hearing a lot of discussion from all attorneys, from members of the bench, talking about who's the boss, whose power is subordinate, whose power is superior. For whatever it's worth, I invite counsel and all others interested to note that in our representative democracy, it is the will of the people, as expressed through the legislature, which enjoys primacy, unless those actions are demonstrated beyond a reasonable doubt to be unconstitutional. So I just need to add that. I've been hearing too much about who the boss is. Well, let's turn our attention to who the real boss is. Thank you. That's enough.
Counsel, do you have an answer to that question? Because I have a follow-up. Do you need to answer that?
Well, I mean, I agree that ultimately, unless there's some constitutional restriction that, you know, the legislature can do what it wants.
Established beyond a reasonable doubt.
That's absolutely correct.
You're finished with the answer to the
I am.
question? Okay. I've read Thompson, and I've read the briefs, and your last sentence in your brief says overruled Thompson. I find it hard to understand the argument now of Thompson maybe doesn't need overruling. For instance, earlier in the questions, you responded to a letter from Harvey in 1902. Thompson, the case of Thompson, addressed those letters at page 692 and 693, and came to the conclusion of directly opposite of what you are arguing as to what those letters meant. So at least that part of Thompson has to be overruled, doesn't it?
Thompson's broad language, at least as it's read by the respondents, would have to be overruled, because to the extent that you read Thompson to say that not a single power can be given to anyone else, or that not a single power can be given to the superintendent that is then checked by anyone else, then it seems to me that Thompson is wrong. Of course, that wasn't the case in Thompson. The superintendent had been largely rendered superfluous. And, you know, I know from a long career practicing law that oftentimes a court will go back and it will look at language that it adopted in addressing the issue before it and say, look, you know, to the extent that this language can be read to mean such and such, that understanding is disavowed. What we said at the beginning of our brief is that we thought that the important thing was that the correct interpretation of Article 10, Section 1 be made clear, because right now, the broad language of Thompson, particularly given the way that it has been interpreted by the public instruction, Department of Public Instruction, has impeded the development of innovative solutions in the area of educational reform. And so if Thompson has to be overruled to do that, so be it. If this court, after considering Thompson, believes that it may say that we simply are clarifying the rationale in Thompson, that we are saying that, no, we did not go as far in 1996 as the Department of Public Instruction, and the plaintiffs in this case believe that we went. I think that that's fine. To some extent, it becomes a sort of a metaphysical question as to whether you're doing the one or you're doing the other, and I find it sort of easier to talk about the outcome than the characterization of it.
You know, Professor, you were put at a disadvantage because you were asked a misleading question by Justice Bradley. As the concurrence points out, the majority did not cite at all the letter that I quoted from and which you endorsed. It was cited only in Justice Wilcox's concurrence. And so therefore, I think you are entitled to know you have not contradicted yourself as far as I know.
I try not to contradict myself. I hope I'm successful most of the time.
Good. Thank you very much,
Just one
counsel.
follow-up question. You start your brief citing Justice Wilcox's concurrence and then end your brief saying, and espousing the concurrence is correct, and end the brief saying that Thompson should be overruled. One of the things that I smiled in reading your brief was citing for the premise of Johnson controls, citing Johnson controls for the premise of the importance of stare decisis. Stare decisis, of course, means, I'll use vernacular, we're wedded to precedent. Precedent should stand. And I recalled, because I joined in Justice Wilcox's dissent in Johnson controls, where he said, the only thing that has changed is the personnel of this court and this court's view as to the proper definition of damages in suit. And then he goes on to quote some other authorities about, this is a court of law and not of personalities. What has changed in the 20 years that should cause us to overrule a unanimous decision?
What has changed is that this case is here today, that a decision which said that you can't make the state superintendent superfluous has now been turned into a rationale for saying that the state superintendent has a vested executive authority that may not be shared with anyone else, that is in fact more absolute than that allocated to the governor, because we know that the legislature often allocates administrative responsibilities to someone else. What's happened is that we've seen, as Justice Wilcox and Steinmetz feared, that this broad language would take us to a place which is well beyond that which was before the court in Thompson. And although stare decisis is very, very important, this is not a case where private parties simply have to allocate themselves to a rule that may be wrong. This is a case which goes to the understanding of our Constitution, and as Justice Gableman points out, the prerogative of the people's elected representatives. And in that case, I think, there is a particular obligation
But what's changed in the last...
to get it right. What's gotten it...
Yes, can you answer that just real...
Again,
shortly?
what's happened is that the implications that Justice Wilcox and Steinmetz feared, which the majority was not concerned about, have actually come to pass.
Okay.
That this rationale is being used in a way which is far more capacious and goes well beyond what was before the court in 1996.
You mentioned Justice Wilcox's concurrence, and let the record reflect that the Harvey letters are part of the majority on pages 692 and 693, the concurrence beginning on page 700. So,
Thank you very much, Justice Bradley, and thank you, counsel. We'll now move on to the respondents. I want you all to know that I didn't chide my colleagues today about adhering to the red lights. Counsel is always very good about looking at the red lights. The court is often bad, and in the past, since I began as Chief Justice, I tried to remind my colleagues to please mind the red lights so we are fair to both sides. At this point, according to my watch, and I don't have a stopwatch, The petitioners have gotten 20 minutes because of the court's questions after the red light went on. So I will allocate more time to the respondents so that you are treated fairly, Tina. And I don't know how you can do that with the lights, but it is the court's problem the court has created, and I do not want to treat one side unfairly. So I want to be sure you have a similar opportunity to give your case and to answer questions from the bench. Thank you.
Thank you, Your Honor. May it please the court? Good morning. My name is Susan Crawford. I am here representing the plaintiffs' respondents, Peggy Coyne et al. They're a group of taxpayers, parents of school children, and public school teachers. What we're asking the court to hold today is that specific provisions of Act 21 put the governor in control of the rulemaking of the superintendent of public instruction and thereby violate Article 10, Section 1 of the Wisconsin Constitution. The central issue.
Make sure you speak up,
Oh, I'm
counsel.
sorry.
The acoustics here are challenging.
Try to move a little closer to the mic.
Thank you.
The central issue in this case was decided by this court just about 20 years ago in Thompson versus Craney, which held that Article 10, Section 1 vests the supervision of public instruction in the superintendent of public instruction, and that while the legislature may prescribe the superintendent's powers and duties, it cannot make the superintendent subordinate to another officer in carrying out those duties. And that's exactly what Act 21 does. It makes the superintendent subordinate to the governor and the Secretary of Administration when making rules for public instruction. It requires the superintendent to get the governor's approval before even drafting a rule and also before submitting a proposed rule to the legislature for its review. It treats the superintendent, Act 21, treats the superintendent exactly the same as a cabinet secretary who's appointed by the governor and serves at the pleasure of the governor.
How can that be, as your opposing counsel points out? How can what you say be factually true if the superintendent has the mechanism to go directly to the legislature to seek that which the governor would attempt to veto, and no cabinet secretary would have that authority, and if they tried to exercise it, they probably wouldn't be a cabinet secretary very long, right?
I think, well, certainly that's true. The fact that the legislature, in exercising legislative authority,
Yes.
can go forward and put into place, through legislation, proposed rules that the superintendent would have liked to have proposed, does not mean that, in this case, the governor is not interfering with the executive authority as prescribed by law
So we've
to the
gone
superintendent.
from preventing to interfering. We're now, it's not the governor preventing, it's the governor interfering.
Well, it's both, in my opinion. It's interfering and preventing the superintendent from carrying out duties and responsibilities assigned by the legislature.
Again,
to
we're
the
missing
superintendent.
somebody. We're missing the legislature here. You heard your opposing counsel indicate that what the legislature gives vis-a-vis the rulemaking authority to the various agencies, the legislature can take away. Do you agree with that or disagree?
I agree that the legislature can delegate rulemaking authority to agencies, including the superintendent, and can take away that delegated authority in
And
individual
modify.
circumstances. And modify, correct.
All right, so how does that square with the argument? I mean, it's not a fight. It's being presented to us and to the public a little bit, I think, as a call for a determination of primacy between the governor and the superintendent. And in my estimation, and I'm open to hearing other views, in my estimation, that's leaving a very important player not receiving the same level of attention that it ought to have here, which is the legislature. If we're talking about a legislative power, you know, the three branches, here we are, and then we have the legislative branch, and we have the executive, both the governor and the superintendent. So really, we're not talking exclusively about an interplay between two executive officers. We're talking about the interplay of the legislature and the legislative power to delegate basically legislative authority. We call it rulemaking authority, but it has the force of law. People can go to jail for violating administrative codes. It has the force of law. They can lose their homes. They can be fined $1,000 a day. So how is it? This is what I'm interested in. Of course, as I said, I'm interested in the particular players in this litigation, but I want to know how this plays out in the future. And I guess it boils down to a pretty simple concept of why is it what the legislature has done here in its exercise of its lawful authority, as you and I just agreed a minute ago, to modify the rulemaking authority that it is granted to the department. Why has what the legislature done, why is that impermissible?
I think it's important to look at administrative rulemaking and what function rulemaking serves in modern-day government. This court has described rulemaking as the way that the executive branch gives effect to legislative policies. It's the way that the agencies, in this case the superintendent, administer the public education system in accordance with the policies.
Those are statements of goals, not always of fact, as we know.
Please continue.
Yes, please continue.
The Article 10, Section 1 of the Constitution uses the words vesting authority to supervise public instruction. It also provides that the legislature may assign powers and duties to the superintendent in order to carry out that supervisory role. In many instances, the legislature has assigned duties and responsibilities to the superintendent to make rules so that legislative policy, written large, can be put into effect across the 2,200 public schools serving over 900,000 students in our public education system. What Article 10, Section 1, the principle that Article 10, Section 1 stands for, as articulated by this court in Thompson, is that the legislature can assign duties and responsibilities to the superintendent. It can modify those duties, it can take away those duties, but it cannot place another officer in a position superior to the superintendent in carrying out those duties, and that's what the problem is.
But the 1902 amendment says, the supervision of public instruction shall be vested in a state superintendent, so far so good, and such other officers as the legislature shall direct. So what is your...
And the court in Thompson gave a very careful look at that language and engaged in an extremely thorough analysis of that language, looking at both the meaning of the words themselves, the historical setting in which they were adopted by the framers.
The letters
and the
you're
first,
talking about.
among other things,
Right,
yes, Your Honor.
yeah.
And the first laws that were enacted after the Constitution was adopted. And it determined, first of all, that there was ambiguity as to whether those other officers were intended by the framers of the Constitution to be subordinate officers, to be local officers that were supervising the district schools, or whether they were intended to be other officers that are on par or equal to the superintendent. The court, after looking at that historical record, including the letters of Superintendent Harvey, concluded that those other officers referenced in Article 10, Section 1 were local officers who were intended to be subordinate to the the superintendent of public instruction. The amicus and the state present no reason for this court to overturn its careful reading and its interpretation of that language in the Wisconsin Constitution. That language has stood for over 20 years as the leading authority interpreting that constitutional provision, and up until very recently with the enactment of Act 21, there's been no reason to
Sure, and that starts out
question
where
it.
you began, or that kind of winds up where you began with it, which is Thompson. We've had Thompson for 20 years, and what's wrong with it, and a careful study. But that raises an issue which is not as seldom necessary to address as we would like, which is what do we do with case law? And now Chief Justice Roberts gave a very eloquent response during his confirmation hearings, where he gave a 3-factor test, which is if a new judge or a new justice comes on board and decides that, gee, that 20-year-old case, I'm not sure the court got it right in that matter. Now, that doesn't, in Chief Justice Roberts' view, and in mine, that doesn't automatically lead to a reason to say, gee, just because the legal reasoning behind it was a little more infirm than I would have liked to have seen, that doesn't automatically lead a judge or justice to vote to overrule it. But I invite your comment, the same as I did with one of your opposing counsel. Justice Wilcox, at page 702, in his concurrence, he repeated a letter that had been cited by the majority, and then he said a similar sentiment as represented in another letter of Harvey's, not cited by the majority, in which he stated, now here's the sentence that's the relevant part, the only purpose in the amendment beyond that of making it possible to put the election of county superintendents in the spring was to make the provision broad enough to meet any demand of the people at any time in the future in the organization of the school system. So that seems a little different from the language that had been focused on.
Well, with all due respect to Justice Wilcox, I think that he was taking portions of that letter out of context and also reading in an inference that is not present in Superintendent Harvey's correspondence.
Spell that out, please.
Well, if you look at the letters of Superintendent Harvey, and I have, I've reviewed all of that correspondence, his concern was that the local officials, then in charge of the schools at that local level, were elected in partisan elections, and that people who were running for those offices were not necessarily people who were experts in public education or were looking at that as their career and their life's work, but rather were using that office, then a partisan elective office, as a stepping stone to higher office. And Superintendent Harvey was concerned with having those local officials be individuals who were properly focused on public education and wanted to ensure that the Constitution allowed the legislature at some point to change the way that those local officials are elected, appointed, how their qualifications are determined. He does not at any point in that correspondence suggest that those local officials should be on par with the same powers and responsibilities as the superintendent of public instruction.
I don't think anybody's contending that.
His position was that the local officials are.
Justice Prosser has a question.
May I ask you a hypothetical question? Suppose Act 21 applied only to the Department of Corrections. Would there be any problem with it?
I don't think that there would be, Your Honor. Requiring the Department of Corrections to run its rules or proposed rules by the governor when that is a cabinet agency whose secretary is appointed by and serving at the pleasure of the governor. This seems consistent with the governor's executive authority over that area.